Hey everyone, I wanted to talk to you today about requests for evidence, otherwise known as RFEs. They're issued by the U.S. Immigration Service after you have filed a petition or some sort of application, and they need more information. They'll send out this request for evidence. So, as many of you probably know, there has been a massive increase in the number of RFEs that the Immigration Service has been issuing. And today I wanted to talk about RFEs for EB-1A petitions specifically. So yeah, as across the board, there's just been a huge increase in the number of RFEs, which is why I thought it would be useful to take some time to understand the RFE letter that you get. Most of it is the same as other RFE letters that perhaps other EB-1A visa applicants get. And I wanted to kind of focus on what you should look for, what you can just kind of disregard, things like that. So let's get started. So when you get an RFE, it used to be that if you filed with premium processing, you would get an email with the RFE attached to it. The Immigration Service doesn't do that anymore. So you have to wait for your RFE letter to arrive in the mail, which takes sometimes up to 2 weeks. So and you may get it before your attorney gets it if you have an attorney. So you get the letter, and the first page will say request for evidence. Make sure they are sending, they have your right name. I've seen people get the wrong RFEs for another person, so double check that your name is accurate. Also, they'll have your A number and your receipt number also on the letter. And as I said, it'll say request for evidence, so you'll know. The first thing to look for on that first page is the due date. They always put it on the first page. It's always in bold. And it says your request must be received in this office by, and it has a date there. So of course you have to issue your response by that date. And usually, it's about 90 days from the date of the RFE letter. They give you about 90 days. So that's very important. There's also this language about if you are submitting documents in a language other than English, then you have to give a translation. So then when you move on to the second page, again, I'm focused on the EB-1A RFE. They'll run through, what the EB-1A is, what are the requirements, things like that. That's most of the second page. And then they will kind of list which criteria you are applying for. So that's when you need to start paying attention to make sure that they have listed the criteria accurately. And then they'll move on. Usually now we're on to maybe the third page where they start actually diving in to which criteria you meet, which criteria you don't. And they should offer a reasonable explanation of why you do not meet the criteria. So they'll go one by one based on what criteria you're applying for. So let's, for example, judging, that's the first criteria. If you applied for it, they'll list the criteria. Usually, the first or second sentence will tell you whether you whether you have met the criteria or not. And then they'll kind of, sometimes what they'll do is explain again, like the information you provided to meet this criteria. So they'll say, oh, you provided X, Y, and Z. So it's kind of reiterating. And then they will explain, hopefully, why you don't meet the criterion. I mean, it is upon them to explain to you why you don't meet it without having to guess. Sometimes I've seen a lot of vague language. But I also wanted to point out, don't believe everything that is said in the RFE. The EB-1A is based on a set of laws, regulations. There's a lot of case law. There is the USCIS policy manual. So if what you're reading doesn't appear in any of that, then the Immigration Service very likely is adding an extra restriction on the criteria. Like they're adding kind of additional requirements to make it harder to meet. So that I have seen that routinely with every RFE, that they just add things to make it harder, and it's not required. What I've very often seen in judging is that they will say you need the formal title of a judge to qualify for the judging criterion. And that's so made up. It's not anywhere in the case law, not anywhere in the statute, the regs, the policy manual. I mean, even the classic case of doing peer reviews of papers, you're not called a judge. So things like that. So don't believe everything you read. So question it and make sure what they're asking for is really legit. The second criterion, very often, and I would say every RFE, if you're getting an RFE, is always on original contributions. I really have never seen an RFE where that original contributions is not mentioned. And so what they'll do is kind of list what you've provided, and sometimes the list is not accurate. They'll kind of repeat things that you have said in your petition support letter. It may or may not be accurate. So you have to kind of keep that in mind. What are they looking at when they make this decision about your criteria? Did they even understand what you submitted? And you can kind of get an idea by what the list of documents they reviewed for your case. So if you have original contributions, you get an RFE, they will ask about how your innovation has impacted your domain as a whole. How has it had influence outside of your employer? That is, something routinely happening over the last year. And then they will give you like this template list of evidence that you can submit to show that your work has had influence in the broader field. And it's the same list over and over and over. And then, they usually have this template, like template language about, the major significance part of the criteria is not superfluous. It's, it's the same language I see over and over. And then again, like moving on to your RFE, they, like for role, very often they will state that your organization is not distinguished, or your division of your organization is not distinguished. So again, make sure that they are following the rule of the law, and what they're requesting is required. I mean, with all due respect, it just seems like some of the stuff is just made up and is based on the officer's idea, maybe, of what you need to be extraordinary. But it's you can't, you have to follow the regulations of the EB-1A. So I don't want to spend time going through each and every criteria. I just wanted to make sure that when you read your RFE, you don't just assume everything that they say is accurate. They're using templates a lot. They are also imposing requirements out of nowhere. So those are things to keep in mind as you read your RFE. A prime example is the high compensation criteria. They'll just say, you didn't provide compensation for other people in your field with the same level of education, the same years of experience, same title, same geographic location, same type of company. Obviously you have to show that your comp is higher than others in the field. I mean, I'm literally quoting from the regs. But to go down to that level of like same county, same education level, that's not required, and is so overly burdensome that it's just unfair. So again, you have to provide what you can, as much as you can in response, because you want the officer to approve your application. But again, some of the stuff is not required, and it's probably almost impossible to even provide. And also, don't believe every court case they cite. This is a new thing I've seen where they cite to these court cases, and if you go to the court case, it actually doesn't say what they think they're saying. So I think they're using like templates and just throwing stuff in. And then of course they'll just say, they still have to make a final merits determination. So if I were you, when you get an RFE, respond to what they've listed and then make a really strong final merits argument. And also include, if they granted any of the criteria, include that in your final merits. Okay, I hope this has been helpful. Talk to you soon.